The Mental Capacity Act 2005 and you. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It applies to people aged 16 and over and makes clear who can take decisions, in which situations, and how they should go about this. It also enables people to plan ahead for a time when they may lose the capacity to make decisions for themselves. It covers decisions such as financial, social care, medical treatment, as well as everyday decisions. We all have problems making decisions from time to time, but the Mental Capacity Act is about more than that. It is specifically designed to cover situations where someone is unable to make a decision because the way their mind or brain works is affected, for example by illness or disability, or the effects of drugs or alcohol. At the heart of the Act are the principles that everybody is assumed to be able to make their own decisions, and that if they are finding this difficult, then they will receive help and support to help them make their decisions themselves. The Act protects your rights to make choices about your life. And if you are unable to make decisions, the Act ensures that your wishes are kept central to any decisions made on your behalf. Anybody making a decision on your behalf has to follow a process set out in law which is designed to protect your best interests. You can plan in advance people who you would like to make decisions for you using lasting power of attorney for property and finance decisions and health and welfare decisions. Any person that you appoint can be guided by you using any advance statements you make about your views or preferences, or an advance decision to refuse specific medical treatment. If you have no family or friends that can be consulted about your best interest, then the Act provides for an independent advocate to be appointed on your behalf to ensure that your views are heard where decisions are being made about serious medical treatment or a change in your accommodation. I know this all sounds complicated, but at its simplest, the Mental Capacity Act is a law that makes sure that you are at the heart of any decision made about yourself. The Mental Capacity Act 2005, the 5 key principles. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It applies to people aged 16 and over and makes clear who can take decisions, in which situations, and how they should go about this. We all have problems making decisions from time to time, but the Mental Capacity Act is about more than that. It is specifically designed to cover situations where someone is unable to make a decision because the way their mind or brain works is affected, for example by illness or disability, or the effects of drugs or alcohol. The Act is underpinned by 5 key principles. The aim of these principles is to protect people who lack capacity and to help them take part as much as possible in decisions that affect them. They're there to assist and support people to make particular decisions and not to restrict or control their lives. 1. All adults have the right to make decisions for themselves, unless it can be shown that they are unable to make it. This means that people must not assume that someone cannot make decisions for themselves just because they have a particular medical condition or disability, or because they are of a particular age or appearance. 2. Everyone should be given all the help and support they need to make a decision before anyone concludes that they cannot make their own decision. This means that everyone helping to care for someone must make an effort to provide all the necessary information in a way the person can understand, and then make it easy for them to try and explain their preferences. This may be through different ways of communicating. For example, it may be easier for a person to understand something presented with pictures or sign language. 3. People are allowed to make what we might think is an unwise or eccentric decision. We cannot say that the person does not have the capacity to make the decision because we think the decision is unwise. Many people make unwise decisions, but this alone does not mean that they lack capacity to make decisions for themselves. 4. Any actions taken or decisions made on behalf of someone who lacks capacity must be done in their best interests after considering what is known about their preferences. It is essential to involve the person wherever possible in making the decision. 5. The final principle of the Act is to make sure that people who lack capacity are not restricted unnecessarily. When making a decision for someone who lacks capacity, you must consider what course of action will interfere the least with the freedoms and rights of that person. These principles must be considered by any person caring for or working with a person who may find decision-making difficult. They are set out in law and must be followed. The Mental Capacity Act 2005. How to determine a person's ability to make their own decisions. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It applies to people aged 16 and over and makes clear who can take decisions, in which situations, and how they should go about this. We all have problems making decisions from time to time, but the Mental Capacity Act is about more than that. It is specifically designed to cover situations where somebody is unable to make a decision because the way their mind or brain works is affected. For example, by illness or disability, or the effects of drugs or alcohol. Where you are caring for somebody who may find decision-making difficult, you might find yourself in a position where you have to judge whether they have the mental capacity to make a particular decision for themselves. This could be as simple as what they are going to wear or what to eat. If a decision is about something more complex, it may be that a health or social care professional or solicitor will help determine their mental capacity. The law says that before you act on behalf of somebody else, you must have reasonable belief that the person lacks capacity to make decisions for themselves. You are not expected to be an expert in assessing capacity, but you do need to have reasonable belief that they lack mental capacity. Reasonable belief can be determined by checking the following steps. 1. Can the person understand information about the specific decision? It is really important that you try as hard as possible to help that person understand the information. This could be as simple as making sure they've got their glasses on, writing the information down, or showing them pictures or objects. 2. Can the person retain the information about the specific decision? A person only needs to retain the information long enough to make the decision. For more complex decisions, the person may need to retain the information for longer. 3. Is the person able to weigh up the information as part of their decision-making process? This means that a person really needs to be able to show some insight into the risks and consequences to their health, well-being and safety in making or not making the decision. 4. Is the person able to communicate the decision to you? This means using any method that is appropriate for that person. If a person can understand and retain information relevant to the decision, use and weigh information and communicate their decision to you, then they are legally deemed to have the mental capacity to make that decision themselves. But if they have difficulty in just one of the 4 areas, then you have established a reasonable belief that they lack capacity. The Mental Capacity Act also sets out how to make a decision for somebody in their best interest. The Mental Capacity Act 2005, how to determine a person's ability to make their own decisions for professionals. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It applies to people aged 16 and over and makes clear who can take decisions, in which situations, and how they should go about this. The starting premise will always be that a person has mental capacity. You will need to pay regards to the act in situations where you have a reason to doubt a person's capacity. The law says that before you act on behalf of somebody else, you must demonstrate and evidence reasonable belief that the person lacks capacity to make decisions for themselves. There are two stages to this process. You must first determine if the person has an impairment of or disturbance in the functioning of the mind or brain. This could be caused by anything from an impact of an infection or the use of drugs, through to something much more permanent, such as a dementia. It doesn't have to be a clinical diagnosis, but a statement to describe the type of impairment or disturbance will be necessary. The next step is to establish whether this impairment or disturbance impacts upon their ability to make the decision. You need to assess their ability in the following 4 areas. 1. Can the person understand information about the specific decision? It is really important that you try as hard as possible to help that person understand the information. This should include the nature of the decision and why it is necessary, and the risks and consequences attached to that decision. You need to consider how you provide that information. This could be as simple as making sure they've got their glasses on, writing the information down, or showing them objects or pictures. You may need to consider using an interpreter or speech and language therapist. 2. Can the person retain the information about the specific decision? A person only needs to retain the information long enough to make the decision, so the more complex the decision, the longer the person may need to retain the information to make the decision. 3. Is the person able to weigh up the information as part of their decision-making process? This means that a person really needs to be able to show some insight into the risks and consequences to their health, well-being, and safety in making or not making the decision. 4. Is the person able to communicate their decision to you? This means using any method that is appropriate for that person. Do they need pen and paper? Do they need photographs or objects? If the person is unable to do just one of these things, then you have established a reasonable belief that they lack mental capacity to make that decision themselves. It is important to remember that the Act considers somebody's capacity on a decision-by-decision basis. As the assessor, it is your duty to be clear about the decision you are going to assess, that you have all the relevant information about that decision, and you have thought about how you are going to communicate this information as part of the process. Having assessed someone lacking capacity, the Act provides statutory guidance on how to make this decision in their best interest. It is the law that you follow this process. The Mental Capacity Act 2005, Lasting Power of Attorney. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It makes clear who can take decisions, in which situations, and how they should go about this. It also enables people to plan ahead for a time when they may lose the capacity to make decisions for themselves. The Act allows you to appoint people to make decisions for you in the event that you are unable to make them for yourself. This is called a lasting power of attorney, and the people you appoint are called attorneys. You must be 18 or over and have mental capacity. the ability to make your own decisions in order to appoint an attorney. This gives you more control over what happens to you if you have an accident or an illness and can't make decisions at the time they need to be made if you lack mental capacity. There are two different types of lasting power of attorney. One is for the decisions about property and finance. For example, managing your own bank account details and paying your bills. And the other type is for personal welfare decisions, such as consenting to medical treatment or where you will live. The attorney's role is to make decisions on your behalf and in your best interest. Any decision they make is legally considered as valid as a decision made by you. You should think carefully before choosing someone to act as your attorney. They should be trustworthy, competent and reliable, and should have the skills and ability to carry out the necessary tasks. The lasting power of attorney must be registered with the Office of the Public Guardian before your attorney can make any decisions on your behalf. Health and social care professionals can use the register to check the status of anyone who says they are your attorney. You can find more information about how to make and register a lasting power of attorney from the Office of the Public Guardian. The Mental Capacity Act 2005. How decisions are made for people unable to make decisions themselves. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It applies to people aged 16 and over and makes clear who can take decisions in which situations and how they should go about this. The law says that it is important that every reasonable effort has been made to support the person to make their own decision. If there is a reasonable belief that a person lacks the capacity to make a particular decision, then someone else, such as a carer or professional or attorney, will have to decide what should happen. Although there is no single definition of what would be in a person's best interests, the Act provides a checklist of things to be considered. These have been set as a safeguard to ensure that any decision made on your behalf is not overly controlling or restrictive and is made in consultation with people who have an interest in your welfare. The following issues need to be considered. Whether the decision can be safely delayed in case the person regains the ability to make the decision in the future. A decision cannot be made based on a person's appearance, age, medical condition, or behaviour. All relevant information is considered. The person is involved in the decision as much as possible. The person's wishes, feelings, values, or beliefs are central to the decision-making process. Any advanced decisions made by the person is adhered to. Any advanced statement made by the person is considered. The views of family members, parents, carers, and other relevant people who are interested in the person's welfare are considered. If decisions are being made about medical treatment, they must not be motivated by the desire to bring about death. To make sure that the person is not restricted unnecessarily, is it possible to decide or act in a way that would interfere less with the freedoms and rights of the person? Any health or social care professional should make a record of the decision-making process in case it is challenged at a later date. The Mental Capacity Act 2005. Advanced Decisions and Advanced Statements. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It makes clear who can take decisions, in which situations, and how they should go about this. It also enables people to plan ahead for a time when they may lose the capacity to make decisions for themselves. An advanced statement is where someone records their wishes or preferences about their future treatment or care. This statement must be taken into account when determining what is in their best interest. An advance statement can be about anything: which care home you would like to live in, whether you prefer a shower to a bath, or requesting a certain type of treatment. An advance statement is not legally binding, but should be taken into account when determining what is in their best interest. An advance statement does not have to be in writing, but it's helpful if it is. An advance decision to refuse treatment allows you to set out particular types of treatment you do not want. Advance decisions are legally binding and must be followed by doctors and other health professionals as long as they meet certain conditions. When you make the advance decision, you must be 18 or over and have the mental capacity to make the decision. You must make clear which treatments you are refusing, and you should explain which circumstances the refusal refers to. You cannot make an advance decision to ask for a particular treatment. You can only say which treatments you would refuse. An advance decision does not need to be in writing, unless it is a decision to refuse life-sustaining treatment, but it is helpful to write down your decision so that everyone is clear about your wishes. Some people choose to make an advance decision knowing that it may have the effect of shortening their life. Life-sustaining treatment is any treatment that is needed to keep you alive and without which you might die. There are specific rules to follow if you want to make an advance decision to refuse life-sustaining treatment. The advance decision must be in writing. It must contain a specific statement which says that your advance decision applies even if your life is at risk. It must be signed by you or in your presence by someone you appoint if you're unable to sign. It must be signed in front of a witness and signed by the witness in front of you. The Mental Capacity Act 2005, Deprivation of Liberty Safeguards. Sometimes people are deemed to lack the mental capacity to consent to their accommodation and the measures that have been put into place for them to ensure they remain safe and protected from harm. Often, these decisions can mean that the person's autonomy or freedom of movement need to be restricted in some way. Health and social care staff must consider and act on the following factors when planning care or treatment. 1. The person has been assessed as lacking the mental capacity to consent to their accommodation to enable them to receive care or treatment. 2. The care or treatment cannot be provided in a less restrictive way. 3. The care or treatment must be in line with the statutory best interest checklist. If as a consequence the person is not free to leave their accommodation and the person is subject to continuous supervision and control, then the person has been deprived of their liberty. The deprivation of liberty safeguards provide legal protection for vulnerable people who are and who may become deprived of their liberty. There are 2 different pathways available to safeguard people depending on where the person is accommodated. One route applies to people who are accommodated within their own homes. This will include arrangements such as supported living and educational facilities. An NHS body or the local authority has some level of responsibility for the arrangements that have the effects of depriving the person of their liberty, and they are aged 16 or over. Where this criteria is met, the local authority or the NHS body where the person is ordinarily resident is responsible for making an application to the Court of Protection to seek permission to lawfully deprive the person of their liberty. The second route applies to people who are accommodated in either a hospital, care or nursing home and are aged 18 years and over. It doesn't matter whether the person has been placed under public or private arrangement. Where this criteria is met, the hospital, care or nursing home must make an application to the local authority where the person is ordinarily resident for permission to lawfully deprive the person of their liberty. In either case, local authorities, NHS bodies, care and nursing homes will be responsible for ensuring that they have the right processes in place, such as policies and procedures to enable applications to be made and to be able to provide information about the process. It is important to remember that where a person has been deprived of their liberty, it will be an unlawful deprivation unless the appropriate permission has been sought from the court or local authority. I know this sounds complicated, but if you're involved in this process, there will be someone to support you through it. The Mental Capacity Act 2005 and the role of the Independent Mental Capacity Act advocate. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It makes clear who can take decisions, in which situations, and how they should go about this. It applies to people aged 16 and over and covers decisions such as financial, social care, medical treatment, as well as everyday decisions. Where a person lacks capacity to make an important decision and there is no one else, such as friends or family, who can be consulted, then an independent mental capacity advocate, or IMCA, must be appointed. The IMCA service provides an independent safeguard to protect the person's rights, views, and wishes. It is a legal requirement for health and social care staff to instruct an IMCA when the decision is about 1. Serious medical treatment decisions, 2. When the local authority are proposing to arrange accommodation for someone for longer than 8 weeks, 3. When an NHS body is proposing to arrange accommodation for someone for longer than 28 days, 4. Supporting people through the deprivation of liberty safeguards process. The Act also allows the local authority or the NHS body to extend the function of the IMCA in cases of 1. Care reviews, 2. Safeguarding of adult cases. Although these additional functions of the IMCA service are discretionary, it is really important that staff consider the benefits of instructing an IMCA as a way of ensuring the person is safeguarded as much as possible. Now we have identified the legal position in terms of instructing an IMCA, let's explore their role. Most importantly, the IMCA will support the person through the decision-making process and safeguard their rights and entitlements. They will do this by finding out the person's wishes, feelings, values and beliefs, and then represent them within the decision-making process. Where they feel it's appropriate, they will challenge the decision. As part of their work, IMCAs have the right to meet with the person on their own and access copies of the person's health and social care records. They are also entitled to photocopy relevant information and take it with them. If an IMCA feel it necessary, they will request a second medical opinion. They will submit a report outlining the IMCA's investigation and make conclusions that staff must consider. Finally, IMCAs need not be instructed when the decision is urgent. The service is not an emergency service.